recent ruling by the court puts the parties on a collision course in front of each other in court this month in August, as the attorneys will square off on the motion for limited discovery that Manson's attorneys have filed. Then in September, the anti-slapp motion gets real. So the question is, who's going to win, and what are they going to win? Let's take a closer look than I have before, at least, at this anti-slapp motion, and then how the limited discovery request plays into that. As you probably know, but just to say it again, the anti-slapp procedure in California gives defendants an early way to test a case if that case involves certain protected activities involving speech. Manson's case has 4 causes of action in it: working from top to bottom, impersonation over the internet, violation of Computer Data and Fraud Act, defamation per se, and intentional infliction of emotional distress. Now, the anti-slapp motions by the defendants do not attack all of these causes of action. Instead, it attacks them in 3 ways, which is pretty much the most ways you can in California. So a cause of action in California can be one that does not involve protected activity under the anti-slapp motion, so it doesn't come under it at all. It can be one that clearly does have protected activity in it, so it gets tested in the anti-slapp motion. And then there can be one that's mixed, which has allegations that don't involve protected activity and allegations that do involve protected activity. And Manson's complaint appears to have all 3. At times in this video, I'm going to show a copy of the complaint that has highlighting on it. If the highlighting is green, that is text in Manson's lawsuit that both defendants asked the court to strike. If the text is blue, that is material that only Wood has asked the court to strike. There is no material in the lawsuit that I found that Gore asked to be struck that Wood does not also join in. So there won't be any of that for the bottom 2 causes of action, which involve impersonation over the internet and the computer fraud cause of action. The defendants have not requested that the allegations or causes of action relating to those 2 items be struck. So it seems like everybody agrees whether they're true or not, and they don't concede that they're true. There's no argument that if they were true, that they would come under the protection of the anti-slapp law. So those causes of action are not at stake for the motion that's coming up, and they won't go away, which means even if the defendants get everything they want, this lawsuit will carry on those 2 causes of action. Then there's defamation per se, and the defendants both ask the court to completely strike that entire claim. Just throw it out. They say that it's all protected activity, and he's not going to be able to show that he could win on that claim, so court, please toss it out. So there's the 2 that are completely outside the scope of the motion, and the one that they say is entirely inside the scope of the motion. And then there's the 4th one, which is intentional infliction of emotional distress, and the defendants ask the court to strike some of the allegations that support that cause of action, and then because of some law we'll talk about, therefore strike that cause of action. So they're asking for 2 of the 4 causes of action to be thrown out if they're successful in the anti-slapp motions. So in the anti-slapp environment, you have to show 2 things. First, the defendants need to show that the conduct alleged comes under a protected category. If they do that, the burden's going to switch over to the plaintiff to show, I have evidence that will show you, judge, that if you just let me get to court, I can win. Not that I certainly will win, but that I can win. They can't rely just on the complaint. They can't just go off the pleadings. It's not a motion to dismiss like that. They have to show up with some evidence that could be admissible in trial to support the elements of the cause of action if they want to get past the anti-slapp motion, assuming that the court agrees it's protected activity. So the anti-slapp protected activity is pretty broad spectrum of speech. I think talking about what was talked about in this defamation per se context, the nature of this groupie movie, those statements probably going to come under that. However, all that means is that you do get to be evaluated under the anti-slapp standard of, does the plaintiff have enough evidence to let this case go forward? So the defendant's arguments here are not the strongest to me to have it thrown out, which is basically, and I knew this was coming, I said this way back at the beginning of looking at this trial, they're going to try and use his own words against him when he was in that dinner for 5 or whatever it was, and they talked about this movie a little bit, that he was like, well, the actress could have been younger, could have been older or whatever. But I think any fair reading of that, anybody who saw it saw that after that he said he was joking and that, in fact, this person was over the age of consent as an adult. So if you're running off of that to say, well, that's the reason that I thought he committed this kind of act against minors, maybe someone even died over it, that seems pretty lean to me. That's not, to me, a particularly good defense to the claim at this stage of the case. And Gore cites, her attorney cite in her brief, that there are other stories about Manson, engaging in improper conduct with young people or whatever. Well, that doesn't support making a specific allegation in a specific context. That's just general comments. That doesn't give you the ability to just make a defamatory statement that specifically is driven at something, unless you've got some reason to think that. They also say because Manson is a public figure that there has to be actual malice, evidence of that, and he's not going to be able to show it. Yeah, maybe, but that one I don't buy either. I mean, can anybody on either side of this case doubt that Wood and Gore really wanted to go after Manson? And he cites some evidence of that in his complaint. So this seems not very persuasive reasons to just drop this out of the lawsuit. However, Manson still has to meet the burden of bringing forward some evidence on all the elements, so he's going to have to show that. And to me, the flip side of this is that it's a little weak what he said in his complaint, that they were telling other people this. It's really vague. Like, who were they telling this to? When exactly? So those kind of things were left out of there, and then maybe could cause him problems as they get to the hearing. However, when we get to the discovery piece of this, you'll see that what he's trying to do is shore that up, that they actually name a person who they say was told this statement to, and that she would be willing to testify to it in a deposition, and that's one of the reasons why he wants a deposition. So good argument by Manson's attorneys there, because I see this as the weakness on his cause of action, and he's telling the court, I've got the person. All we got to do is be able to be allowed by the court to take a deposition, and I'll lay the evidence right in front of you that what we say happened did in fact happen. So this cause of action, it's a reasonable chance of going forward. It's a little weak right now. If he gets the discovery, and it shows what he says it's going to show, then it probably would survive, in my opinion. This leaves us with the first cause of action in Manson's lawsuit, intentional infliction of emotional distress, and to my mind the most interesting for the purposes of this motion, because it's the quote-unquote mixed cause of action. It's so complicated, I'm breaking out the progressive glasses for it. So there are a lot of things in the lawsuit before the causes of action are laid out that the defendants are trying to strike. I'll just show some of them on the screen as we go through. They primarily relate to the speech that the defendants engaged in, talking to other people, talking about the abuse, that sort of thing, that's a protected conduct, they say. That doesn't mean immunity. That means that when it is protected like that, the plaintiff will have to show that he's likely to succeed on the case in order to get past the anti-slapp. That's what that means. It means it gets reviewed at the anti-slapp stage. So they want to knock a lot of those things out. But if you remember when we showed the defamation page, the defendants are like, get rid of all of that. Well, that's not how they handle it in this first cause of action, where they target the protected conduct allegations of the cause of action, not all the allegations. So let's see what they want to knock out. Wood wants to knock out the claim about falsifying correspondence from a fictitious federal agent. Gore doesn't join that, but Wood is asking the court to knock that out. They both want to knock out making knowingly false and defamatory statements against Warner, that the actress in the groupie video was a minor and Warner was manufacturing, pornography, so of an illegal sort. And they want to knock out recruiting, coordinating, and pressuring multiple women to make false accusations against Warner and be part of their film project. Now, here's why it's really important that they win the first battle, which is, judge, these are the sorts of statements, whether they're true or not true, and to some degree even for what purpose they were done, that come under the protections of the anti-slapp statute. That you need to force Manson to come forward and prove that he's got evidence for these things. And the reason is because the California Supreme Court has issued a decision in the past that says that when you look at a mixed cause of action that has unprotected activity in it and protected activity in it, that you disregard the unprotected activity for purposes of assessing the cause of action. So if they were to show that these things are protected activities, and then Manson cannot meet his burden to show that he has enough evidence to make a claim based on that, the court could strike the intentional infliction of emotional distress cause of action without looking at the other allegations that he made to support it. So that's pretty important for them to win on this. Now, what they left out of here, and so it's not going to be addressed at the anti-slapp motion, is the swatting situation, the alleged swatting situation. So they're not addressing that. They don't even ask for it to be struck. And soliciting and receiving logins and passwords and things, we already mentioned that's a basis for a different cause of action. They haven't asked for that to be struck either. However, if they win on these other allegations about their speech, and the judge says, well, I don't think you have enough evidence on those 2 or 3 things, depending on how the judge views this, the judge could throw this out, this cause of action out, even if they did swat, even if they did use the passwords, because he would be striking the cause of action. So it'd still be in the lawsuit saying, hey, they swatted him and they stole these passwords and used the social media, so that's the basis of a different cause of action. But this infliction of emotional distress claim would be gone. So nice strategy by the defense attorneys here to use this California case law to say, let's just set that aside, Judge, because if we did swat him, if we did do these things with social media, we're not contending that that comes under the anti-slapp, but it was the plaintiff's choice to put those things together with these other items, which are critical to his infliction of emotional distress claim, that are protected under the anti-slapp statute. So he has to prove those things would be enough for him to move forward with his case without regard to the unprotected conduct. So the law gets pretty confusing. There's some other cases that parse this different ways, but the general idea that they're citing, it seems to be supported by California case law, which is in a mixed cause of action, the judge will disregard the unprotected activity and assess the value of the cause of action based on whether the protected activity supports it or not. So that gets down to, first, he's got to show the evidence of these things. And we'll go over a little bit of that in discovery, what he says he has and what he says he's going to get, which would relate to this fake letter and statements made about Warner, the groupie video and all that, and the recruiting and pressuring women to make false accusations against him. He's going to need to show evidence to support those things if the judge buys that those are protected activity. They don't need to discuss the swatting or any of the rest of it. And then, if he does have evidence to show those things, are those things outrageous enough conduct to be considered intentional, a basis for an intentional infliction of emotional distress claim in California? Not just any conduct can do that. Not just any bad conduct can do that. Not just any false accusation can do it. It's not just a substitute for I feel bad that these people did this, so judge, let me sue them. The conduct has to be pretty outrageous. And again, the swatting I think kind of is, but you don't look at it for purpose of this motion because it's not in play here. So it has to be the things that the defendants are talking about. And so the assessment is whether this fake letter and the false defamatory statements and the recruiting and coordinating, whether those things, if those 3 things together is that intentional, or are those enough actions to intentionally inflict emotional distress on somebody. Then it gets a little bit hairier because remember, Wood is the only person trying to knock out this FBI letter and the creation of it. And her attorneys make the argument that under the law, because if it was prepared and used, it was prepared and used in a court battle with her child's father, that's in preparation and use in a court proceeding, and so it is privileged from being used in this lawsuit like this. It's a good argument. It's an interesting argument because Manson's claim that this letter was part of the scheme to inflict emotional distress on him and go against him is pretty thinly pleaded in his lawsuit, and I don't see that it's backed by any more evidence than that. Now remember, when you see a legal document like a complaint or an affidavit or declaration one of the parties' files or whatever, the lawyers don't say, hey, why don't you write up what you think and I'll get it filed with the court. They don't do that at deposition either. All of this is prepared in advance. If your client's going to be in a deposition, you go over that testimony ahead of time a lot. You see how they're going to answer the questions that are going to likely be asked. You talk about that. You try and get the client to the right frame of mind to do the best they can for their case. Likewise, on these kind of documents, you consult with the client and then you write it, okay? Generally speaking, you write it. So this is going through filters. And there's what the client says and there's how the lawyer spins it, and then it gets filed. So when there are intelligent clients and intelligent lawyers like there are on this case, I look for what they say, how they say it, and also what they don't say when you might expect them to speak on a topic. The choices they make in terms of what they put in something or don't put in it, they're not casual. They're not just whipping this out while they're in between scrolling through Instagram. They're thinking about what they're doing. They're pushing things where they can push it. They're not putting things in where it might hurt them. So take that into consideration when you read either side's documents. And look, for example, in Manson's complaint, paragraph 37, it starts off, upon information and belief, Gore aided and abetted Wood, etc. Now, upon information and belief, sometimes you see in the complaint just affirmative things like Gore swatted. When you're a little dicier on the information you have, not that you don't have any, but dicier, then you start talking about upon information and belief. It doesn't sound quite as strong as I know this happened, does it? So a little equivocating, nothing wrong with it. That's in complaints all the time. But I light up if I'm the defense attorney looking at this saying, well, let's see how far they're pushing what they're talking about here, because it's nothing they've got direct evidence on that they're citing in the complaint. And it says the forged letter, and it's interesting to me, Manson's attorneys make a big deal in their briefs about the forgery of this letter being the really bad act, even more so than the impersonation. That the letter would help Wood, and that certainly I think is why it was created, that the letter would be picked up by the press and draw attention to Phoenix Act and false allegations against Warner. The forged letter would be used to recruit, encourage, and convince people. Would be used. It doesn't say it was used. I mean, if they handed it to somebody and said, look at this, can you believe this federal investigation? And if you don't join in, then there's something bad could happen to you. So you need to work with us to talk bad stuff about Manson. Then it would have been used. But it says it would be used, not that it was used. So to me, that indicates they don't have evidence that this letter was used with any of the specific victims in this recruitment process. It's very thin to connect this letter to the recruitment process. It says it would be used. Now they can, obviously make the argument, hey, we're just talking about that it would be after it was made. Okay, it wouldn't be used before it was made, right? Yeah, we're all smart here. Let's get with the times here. I know you want to connect this letter to the recruitment process, and I get how you're saying it, which this makes sense. If it's leaked to the press, then it would naturally be part of the recruitment process if people saw it. I get that. But also seeing this, that I don't think there's any proof that it was actually used. Like the checklist allegedly was used with these other victims. You don't see the same kind of direct allegation on this recruitment situation. And looking at the letter, did the other video about it, it appears to me that this letter was made to support Wood in her child custody dispute. I don't know who actually wrote the final version of the letter, because the text between Wood and Gore is not the text that ends up on the document that was filed in court, which is also the same image that Brighton Gore attached to her declaration off of the iPad. Where'd that come from? Do we really know who made that version of this letter? And when they made it, why wasn't the two law enforcement contacts at the bottom incorporated into the document typed? Why not? Why was that added later? Nobody wrote that on the screen, I don't think. I think it appears to me that there was some hard copy and somebody wrote those things on there. What's more bizarre about it, and I know trolls don't want to believe it, is the DA who's listed on that version of the document, which is the version that was attached in the court documents, that's a real DA. That email goes to that DA. Still does today, according to bar records. On the right side of it, the Sergeant Jeffrey Walker that the father says he spoke to, that person in public records that I found existed and was on this trafficking task force and was associated with the phone number that was written on this letter. I attached the links to why I think that to my previous video on the letter. Don't you think it's bizarre that if you're going to forge this fake FBI letter that is fake, you wouldn't want it to be around law enforcement, yet somebody writes on this letter before it goes to the child's father legit law enforcement contacts? It's strange. I have my own theories on why that is, and I think, not hide the ball on it, I think it's because it generally was meant to support her contention for why she needed to leave Los Angeles. Remember, the first draft of this thing that she had on the text, if the text is real, more explicitly said you need to get out of Los Angeles. So that was watered down by somebody, but having real law enforcement contacts, and one of them, he says he did call, who would say, well, yeah, there's something we're checking into. that kind of supports what she was saying she was up to. So I feel like that's why this thing was created. Don't know that. But I don't think it was created to recruit people against Manson. Maybe it got used that way, but where's the evidence of that? And I don't see the evidence of that. Now, before you assume any of that means that I think this letter's real or whatever, I don't think that. I think it is fake. And I think the same kind of textual analysis I used to say that Manson's kind of weak on his allegations that this was used to recruit, or even that was its purpose, you can apply that to Wood's declaration in this case. And she talks about this letter, that she believed it to be real when she filed it. She didn't make false statements to the court. Again, these lawyers are smart, talented people. If they had evidence that she currently believed that it was real, this is genuine, why wouldn't you say that? She talked about what she did believe and that she didn't make this false statement. So the implication there is that at the time she got it and submitted it to the court back during this child custody dispute, she thought it was real. There isn't anything in her declaration, obviously, that I saw that says, and I also think it's real. There was also no part of her declaration that said, you know why I thought it was real? Because agent so-and-so gave it to me, put it in my hand on, October whatever, 2020. Agent so-and-so, here's their number, call them, they gave me this letter. Or here's a copy of an email from agent so-and-so forwarding this letter to me. If you wanted to support the fact that the letter is real, it seems like you would recount the story of how you got it. That would be pretty easy to do. Everybody thinks I faked this. I didn't fake it. I got it from so-and-so. Why not put what your basis is? Maybe it wasn't the agent. Maybe it was friend X. Friend X said they got this from the FBI agent and handed it to me. I always believe friend X. Why would you put the basis for continuing to believe it's still real if you do? It seems like they've abandoned this or any hope of suggesting that it was actually real. And they're standing on, okay, it was false. I didn't think it was false. We're not going to test that right now in this case because when I used it, it was in a legal proceeding and that's privileged. And Manson hasn't shown how this was ever designed to be used against him or was actually used in a recruitment against him. So the first point on a legal basis is a pretty good point. It really is, absent showing how she used this outside of that context. And then the second one, that there's no evidence that it was designed or used to recruit other than his opinion that maybe it could have been or would have been. That seems pretty good too. So I get why Manson's attorneys are all over this thing and spend a lot of time on it, because if it is like it appears, it's evidence that at least one, maybe both of the defendants created a false document and then filed it in court to sway the court's opinion on something. I mean, you want that. It's almost a smoking gun in this case. It almost is. If it were filed in this case and proven to be fake, it would be. It's fairly smoking. You found a gun that's smoking that was used somewhere else. I mean, you want to show the defendants are willing to straight lie to the court over a critical matter like the child custody. You want to show that. So of course they want that in this case. But the defendants have some good arguments for why it's not material to this case for the cause of action. Maybe credibility later, but not the cause of action. That becomes critical because that would only leave two things for Manson to have, if they were successful there, to support his infliction of emotional distress claim, which is, generally speaking, false and defamatory statements against Manson, including about the groupie video, and then recruiting, coordinating, and pressuring women to make false accusations. The last one of those, that's generally pretty vague and weak to me. I get that there's the checklist and things like that, but people should be able to talk to each other and say, did this happen to you? It happened to me. There's that end of the spectrum versus a coordinated conspiracy, right, to hurt this guy. And he does have some evidence of that based on what they said. But by itself, all alone, is it a lawsuit? Is it a lawsuit for infliction of emotional distress about the comments about the groupie video? And there, yeah, maybe so, because if you call somebody a pedophile to other people, that's actionable. And that's the defamation per se claim in this lawsuit. That's a bad thing to be saying about somebody. So I like that because if somebody were saying that about me and they were out in the public, I probably would have emotional distress. So I get where he's coming from on that. But still, he's down from this list of things that he had, perhaps only to these bottom two, and those two would have to sustain his cause of action for it to go forward. Manson's attorneys, of course, have started the process of fighting against the anti-slapp motion, and they've done it in two ways. And one is they've submitted additional evidence and declarations that are designed to support his allegations in the complaint. And they've asked the court to allow them to conduct discovery. We'll go over that in a moment, before the motion is heard. So Manson's attorneys make the point that, hey, look, we submitted a declaration that shows one of the victims who sued Manson is saying on social media that she was pressured into doing it, regrets having done it, was told to lie. Now, I've seen also reports on social media that people are saying, well, those things are false. But in front of the court right now, at least, is the allegation that those are true, and that's supported by declarations. If it's supposed to be false, I would expect to see the defendants come up with some declarations showing that. They might even be able to get the woman to file a declaration. If she won't file a declaration on their behalf that she didn't write those DMs, maybe it does suggest it was real. We'll just have to see. My point is, in front of the court right now only is evidence that those things are real. So they're saying we've got a declaration from a victim who says that they were pressured and told to lie. We've got a declaration from an attorney saying that this FBI letter was fake. The FBI agent didn't know anything about it. Got a declaration from Warner that he suffered emotional distress. So we're well on our way, Judge. We're showing that these people were recruited to lie. We've shown that the defendants are producing false information, and all part of a pattern of behavior to harm Warner, to destroy him, as they say in the complaint. But they tell the judge, listen, some of these things involve evidence that we don't directly have under our control, but we could get easily in targeted discovery that is not overly burdensome to the defendants. And we're going to do discovery anyway, because this case is not going to be completely thrown out, even if you did grant these motions. So the defendants will have to go through discovery. And there's some case law to suggest that sometimes discovery is appropriate, and Manson's attorneys say that applies here. And to support the fact that it's targeted, they give the court a forecast of who they want to depose and what the topics are. So the first person on the list, maybe not surprising, is Agent Michelle Langer. They want to depose her. If you remember in the attorney's declaration, they said that Agent Langer said she was not in a position to give any kind of statement on this due to potentially an investigation of the letter issued. So they want to issue a subpoena to this agent and have her testify about the fact that she wasn't involved in this letter, doesn't know anything about it. She never discussed it with anybody. Federal Violent Crimes Department, it's not a real department of the FBI. And how could Gore have gotten to know Agent Langer's name? So that's things they want from this agent. Yeah, that's good stuff there if you can get it. And I do not disagree with their desire to put this letter front and center. Not so much, in obviously, as how it was used to hurt Manson, because I think that's rather lean, but just that it was a false document, apparently submitted to court, and that looks really bad for them. Of course, they want to take deposition of Ilma Gore as well, and they want to authenticate these text messages about the creation of this letter, that Gore and Wood participated together in the creation of the letter, that there was no Agent Langer authority to create this letter, that nobody from the FBI gave Gore, or to her knowledge, Wood this letter. Same thing with Evan Rachel Wood. We want to talk about the same things on this letter. And also they want to depose Michelle Meyer. So remember that there's a Michelle Langer, FBI agent, and there's a Michelle Meyer, potential witness in this case. So they say this person, this Miss Meyer, declined to provide a voluntary statement, but she would accept service of a deposition subpoena. So they're saying, if you'll just let us issue a subpoena, this person will testify to these things, which include some of the text messages that showed in an earlier video that was from a Michelle that Gore knew, texting to Gore, allegedly, saying, hey, I'm getting these calls from people thinking I'm an Agent Langer, which she isn't. How do you want to respond to it? And then Gore responding back, allegedly, I'll take care of it. Someone mixed it up or whatever. So the idea there that Manson's attorneys say is we want to show that Meyer gave her phone number to Gore and communicated with Gore, and then that was used for however reason to become the fake FBI number. And Meyer had nothing to do with that. They also say that Meyer would testify that Gore discussed the Groupie movie with her and the allegations about its child content, and that it was illegal, it was pornography, etc. So that's a pretty important deposition if they can get it. When they do depose Ilma Gore and Evan Rachel Wood, they want to talk about the checklist, communications, the alleged scripts. Weren't those provided to victims? Didn't you use those as talking points for these victims? Didn't you reach out and contact these victims to support the idea that they were coercing victims to lie? Another topic of discussion with the defendants is their state of mind about, which really goes toward the malice aspect of defamation and also the intentional infliction of emotional distress, that they either had this actual malice or they were completely in reckless disregard of the truth and the harm they were going to cause. That they conspired to publish these things about Marilyn Manson to harm him. Another witness in this case is a Catherine McGaffigan, and that allegedly would go to show that Gore was reaching out to McGaffigan and saying that Wood is going to speak about this groupie video, that the person in it was underage, there were many more teens subject to abuse, but McGaffigan didn't participate in the group because allegedly she wasn't a victim of Warner, so they want her to come in there too. So that would be two people that would testify to allegedly the statements about the groupie video. So that's, that was, I think I mentioned a hole earlier, I think in some of his allegations. They're looking to strongly plug that with this discovery. So my theory evaluating this, I guess a couple of weeks ago or a week ago or so, is that Manson stands a good chance of getting past the anti-slapp motions. And with this discovery order, I don't know that that's changed, because as I've given you his forecast of discovery, it sounds pretty good, doesn't it? If he can get the things that he says he can get. I mean, I assumed he would come forward with some declarations, some bombshell declarations, and he's done that. The defendants, we'll see what they do. There's two sides to this story for sure. But if the judge allows the discovery and it goes forward and he gets what he needs out of that, the judge allowing the discovery and then the things they said are going to get, again, this is just to get the case to the next phase, just past the anti-slapp motions. It's not the judge saying that I agree with Manson. It's just, well, you've gotten enough to get past this, we'll let this case go forward. That shouldn't be that hard for him to do. If the judge says, I'm not going to allow any of this discovery at all, maybe that tips the hand that the judge is going to be more skeptical. And then you have to look at, for the protected activity in the intentional infliction of emotional distress, are those three things there, and maybe only two if the judge buys the privilege argument and the non-connection argument on the false letter. Those two or three things, are they enough on the evidence that's in front of the court to sustain an action for intentional infliction of emotional distress? So if the discovery is denied, I tend to think they could get a ruling where this case is narrowed down in scope some. But just guessing, I'm not putting any money on it. We'll see how it goes.